guess you're hiding out in a cave, which at this point seems prudent. You know about the armed conflict in the Middle East, whose epicenter is Iran. The instigators? United States and Israel. On the 28th of February 2026, the United States began a series of strikes against Iran, targeting Iranian leadership. In the attack, the Supreme Leader Ayatollah Ali Khamenei was killed. Along with him, other senior figures were killed. As a response to this attack, Iran fired retaliatory attacks against countries which host the United States military bases. Countries like Saudi Arabia, Dubai, Bahrain, Qatar, Kuwait, United Arab Emirates. These countries have been attacked, and it is effectively causing instability and anxiety in countries within the West Asia. Back to the legal question: preemptive strikes or anticipatory self-defense. What the US is using as justification for the act of aggression against Iran. Does it hold water? Is it recognized in international law? Article 2.4 of the United Nations Charter prohibits use of force. Full stop. There are only two exceptions to this rule: Security Council authorization and self-defense, found in Article 51. And self-defense is not, I feel threatened. It requires an armed attack, or at the very least, an imminent one. Imminent means immediate, overwhelming, leaving no choice. So when the US and Israel strike Iran, citing nuclear development that was reportedly obliterated last summer, and while diplomatic talks were ongoing, the legal question becomes slightly uncomfortable. Was there really an imminent attack? Or was this preventive force striking because of what might happen later? Preventive war is not provided for in the United Nations Charter. Remember Afghanistan in 2001 that followed the 9/11 attack on the United States? That was actual self-defense in international law. What about Iraq in 2003? Weapons of mass destruction that never materialized. That was preventative logic, and it remains legally controversial, much like this case. International law is designed to restrain power, especially powerful states. The test is not whether a state fears a future threat. The test is whether the law permits the use of force before that threat materializes, and that threshold is extremely high. International law allows for self-defense, but only when the threat is instant, overwhelming, leaving no choice. When imminent becomes speculative, we're no longer in the realm of defense, but in the realm of power. I know not what weapons World War III will be fought, but World War IV will be fought with sticks and stones.